And for more on this, we're joined by Eric Lisann. He's a legal expert and a former federal prosecutor in the U.S. Thanks so much for being with us here on France 24. We always appreciate your expertise on legal matters. So a lot of legal experts were expecting the court to issue an actual ruling on this by the end of the day on Wednesday. What does it tell you that they've delayed their decision for another couple of days? Does this give us any hints as to how the justices might rule?
It doesn't give any substantive hints as to which way all 9 of them are going, but it does tell us that they need time to organize their thoughts and present them, and that some of them may be presenting them in a more detailed written format. Remember, this is not a ruling that is technically or procedurally fully disposing of what we call the merits of the actual underlying arguments. It's just a ruling deciding what to do procedurally with the order of the lower court while everything is figured out. And do they leave the original order of the first trial court in place, which is a total ban on this drug mifepristone, or do they leave in the ruling of the intermediate appellate court, which is not a total ban, but a partial ban? It allows it for the first 7 weeks and then imposes restrictions. Or do they return it to the status quo before the original judge in the relatively small town of Amarillo, Texas, intervened in the case? Those are the choices they have, and there's 9 of them. So they need, generally speaking, 5 votes, though on some issues they only need 4 votes, which is a little technical. We don't need to get into that here. But what it tells us is there's not unanimous agreement right away by today or yesterday as to how to proceed on this case. So they're going to regroup until Friday.
You just mentioned the judge in Texas. What do you make of the basis or the strength of his ruling, raising safety concerns about mifepristone? It's been approved by the FDA. It's been used safely for 2 decades. This judge, to my knowledge, doesn't have a medical or a scientific background.
That's right. And in that sense, and in other senses too, procedurally, it's radical what he's done. He's even alarmed big pharma, as we call it, the major pharmaceutical companies, because it's such a change to the way drugs have been regulated in the United States and by the Federal Food and Drug Administration that it would jeopardize much of the way pharmaceutical research and product distribution goes forward. So essentially, he's substituted his own judgment by adopting a very almost extremist right-wing argument, but that has been validated to some extent in the anti-abortion Dobbs ruling, overruling Roe v. Wade, that the scientific community isn't properly weighing the interests of the unborn child or the trauma that abortion supposedly imposes. That's the argument, but it's been forced through procedural deficits that don't accommodate that, because so many years have passed, and that's part of the conflict. Their limitations period has seemingly expired. There's no standing for these people, and prior to this, there's been no mechanism to substitute the judgment of the scientific community that was advising the federal regulators. These are the difficulties behind the original argument, but there are apparently some sympathetic ears in the Supreme Court. Whether it's enough to effectively impose the new standard now is the question.
So when the court overturned Roe versus Wade and took away the federal right to an abortion, it seemed unlikely that the Supreme Court would again take up this issue of abortion. Why is the court stepping in this case?
Yes, that was a myth, really. Whether the court believed it or not at the time is not clear, but obviously that's not the case. But here there's secondary ramifications of this. The same activists that pushed through the reversal of Roe v. Wade are now using that to leverage other issues that are closely tied in with abortion, such as medical care, health care, medicines that are used in the context of pregnancy and treating pregnancy and pregnancy decisions. So it's inevitable that other cases have to resolve this. Now, had they been done under the framework that was existing and still exists, and that the Supreme Court has said must be used, this case would not be here where it is now. But there is the judge in Amarillo. The federal judges can use procedures to impose nationwide jurisdiction, even if they sit in a single judge city, like Amarillo is effectively a single judge district. And it goes through the most radical intermediate appellate court in the United States, which is the Fifth Circuit. And they had also two Trump appointed judges, just like the Amarillo judge, Judge Kaczmarek, and they sympathized largely with the arguments. So now this has landed on the Supreme Court's doorstep, so to speak, and they have to decide whether to bless what's happened here or not. I'll note one other thing which complicates it. Although it's not directly before the Supreme Court in this case, as a practical matter, the Supreme Court has to be aware that there is a competing ruling from a federal district court in the state of Washington, which has said until the Supreme Court intervenes in that case, which covers 17 states, the FDA must continue to allow mifepristone to be distributed as it was prior to this case that's before the Supreme Court now. So that's another issue that the Supreme Court is going to have to deal with sooner or later.
Okay, Eric Lisann, legal expert and former federal prosecutor in the U.S. Thanks as always for your insight. We appreciate you joining us here on France 24.